Hi, my name is Shohin Vance.
And I'm Fran Notarianni.
And we're both members of Kleinbar's Litigation Department. And we also both clerk for the Pennsylvania Supreme Court. I clerk for Chief Justice Tom Saylor.
And I clerk for Justice Kevin Dougherty.
One of the things we often get asked by clients is, what was our experience like clerking, and how does that inform our practice in the appellate courts? So today we're going to take you through the appellate process from the perspective of two former clerks. So for me, it was the ability to dive into novel and interesting areas of the law and the ability and the opportunity to become an expert quickly. Fran, what was your experience like?
I absolutely agree, Shohin. 1 minute you're handling a case where you have to interpret the Workers' Compensation Act, and the next you're doing cases where the rules of criminal procedure are at issue, whether it's their scope or their applicability, and then even cases where there's a constitutional issue at question or an administrative law issue at question. And that requires you to be nimble and to flex different muscles.
And I think that flexibility is something we incorporate into our practice now as well, and we bring that creativity where we can take principles from various areas of the law that perhaps don't occur to other people and apply them more broadly. So, Fran, what do you think are some other ways that we incorporate our experience clerking into our everyday practice?
Research is a big one for me. You touched upon this a bit earlier. We know where to find cases and authorities just because we've surveyed so many different areas of the law during our clerkships. And I know that you're a big writing guy.
Yeah, so I think for me, it was the writing aspect of it. Knowing your audience, knowing what it is that the judges and clerks and justices are looking for, and knowing what it is that will move the needle, so to speak, and the ability to write concisely and precisely in order to accomplish that. But, of course, I think both research and writing are majorly important and go hand in hand. Can't have one without the other. When it comes to writing, one of the biggest mistakes, at least I've seen advocates make, is forgetting their audience and failing to write concisely and precisely. Fran, what are some of the mistakes maybe you've seen lawyers make?
I think another big one is losing sight of the discrete reasons why the Pennsylvania Supreme Court grants aliquotter in cases. When lawyers have a case from day one, they want to tell the court all the things that happened throughout the life of the case, when in reality, a lot of that doesn't matter for the Supreme Court.
Right, and speaking of aliquotter, overuse of jargon, I think, is something that you often see, and it doesn't help your cause. So I think what we're both trying to say here is, in the end, it can be counterproductive to be a subject matter expert in the case, and it can also hinder your chances of appellate review if you've lived the case from day one. I think these are just a few of the reasons why it's vital to speak to an experienced appellate attorney when considering an appeal.
That's right. Our institutional knowledge allows us to see the big picture and look at cases with fresh eyes to help our clients obtain favorable results.